But I can notarize the conversation with Dee if I need to. And then one thing I noticed with Justin was he said that there's been no CPS report, but then he says he's worried about me making CPS reports. So I don't understand that. And then, yes, ignorance is bliss, but in this case, it's a law in every state that you file an intent to relocate as soon as you know, and he knew back in February, and it caused undue stress. In fact, all of this has. And that's why I have PTSD. So until they recognize it, I do object to that argument. That I'm just not seeing her. There's two sides to this behavior. And Dee didn't start visits when I called her. And $50 is a lot an hour to sit in a cubicle. Some more, when it hasn't done any good yet. And then again, the letter from Dee, I understand that they said that some of those events didn't happen, but my concern is the ones that did. And those are the ones that were reported by father and stepmother to Dee, which wasn't her observation, which makes it hearsay. But if it's true, then it needs to be addressed by behavioral health, and that hasn't happened. In the email that he originally gave me, when I first addressed the issue of her house being vacant, was a lie that they were out of town, and I had a police officer report that it was in fact vacant. So it was really unnecessary and, again, undue stress. Outside of that, I don't have anything else to say besides let's move forward and be adults.
Thank you. Well, first of all, thank you for rescheduling this matter, Ms. Adams, allowing it to be continued for Mr. Collier's emergency that he had back on June 15th. And I want to say that your presentation has been logical, and you have presented to the court your beliefs as to the three issues that are before the court. The court's going to go through a little bit of history now, and I'm going to do this because in a sense, we're on the record and I'm making the record. But I'm going to go back because the court has read this file, which took a substantial amount of time. Commissioner Safar also read through this file, which took a significant amount of time. On December 13 of 2016, the court entered findings that the child living with Ms. Adams would be harmful to the child, and that the time that Ms. Adams had the child needed to be limited to protect the child. On December 20 of 2016, a final parenting plan was entered, and in that final parenting plan, there was supervised visitation alternating Sundays from noon until 6, with professional supervision required and to be paid by Ms. Adams. At that point, Dee Cummings was the professional supervisor, and Mr. Duncan was to provide transportation for the child to facilitate that visitation. Also, there was one telephone call per week, and restrictions on parenting were based on what the court found was a long-term emotional problem impacting the ability of Ms. Adams to parent, and also limited decision-making, so that Mr. Duncan was making decisions for the child. The findings of the court were based upon what the court found to be those emotional mental health problems. The court found that there was an inability to cooperate by Ms. Adams, and also there was distance between the parties. The court further issued a restraining order against Ms. Adams. Ms. Adams had moved for reconsideration on January 4th of 2017. The court denied that reconsideration. As was noted by Mr. Collier, there have been several motions or notes for motions and adequate cause requests that have been filed in this matter. Going back to October 2018, 10/2018, the last amended parenting plan, proposed amended parenting plan, with a motion for modification was filed by Ms. Adams. And in that parenting plan, she was requesting no limits on decision making, no supervision, alternating weekends, summer, alternating weeks, half of spring break, half of Christmas break, alternating Thanksgiving, and basically appeared to be somewhere between 89 and 97 additional days of unsupervised visitation. On January 16, 2020, there was a mental health evaluation filed from the Community Mental Health Center, which did diagnose Ms. Adams with a mental illness impairing her daily functioning. Also, in that evaluation, the finding was that intervention was necessary to improve and stabilize Ms. Adams' functioning and to prevent further deterioration. On January 28, 2021, Ms. Adams again moved for adequate cause for modification of the parenting plan and filed a supporting declaration on March 11 and on May 19. Commissioner Zafar did hear this matter on that adequate cause on March 15 and entered a memorandum decision. And then as part of that decision, Mr. Duncan was ordered to provide proof of all necessary medical and dental care, and to do so within 30 days of the order. There is nothing in the memorandum decision of Commissioner Zafar indicating that Mr. Duncan was required to have the children evaluated for mental health issues. Commissioner Zafar did advise in the content of the memorandum decision that if Ms. Adams wished to pursue modification and eliminate supervised visitation, she needed to provide proof of her supervised visitation through D. Cummings and or Susan Bryant to include observations and recommendations showing that the supervision no longer needed to be unsupervised. The court did note that Mr. Duncan could provide contrary evidence throughout mental health, or emotional health impact on the child if that was done. And that leaves us to where we are right now. Ms. Duncan, I think that you may have a misunderstanding of the court's role. The court is not a social service agency. And what the court does is, within the context of the law, make decisions based upon the requests of people and the facts that are presented, as well as the law that applies to those facts, under the rules of evidence and under the rules of procedure that the courts have adopted for the Superior Court. And so the court has to look at the law. And it's clear from what you are requesting that this is a major change in the parenting plan. And under RCW 2609-260, there has to be a showing of a substantial change in the circumstances of the child or in your circumstances. And the declarations do not show that. There also has to be a showing that the present environment of the child is detrimental to the child. There's no showing of that. Clearly, under that statute, this is a major modification. Now, one of the things about subsection 7 of that statute says is that if there have been limitations on your time with the child, it is your burden to show that there has been a substantial change in your circumstances. And the court has received no information. Only information the court has is a letter from D. Cummins from 2018 and the mental health evaluation filed in 2020. Neither of which show that there has been a change that should allow for visitation. And Ms. Adams, as stated by Mr. Collier, the court feels your concern and also feels your frustration. But more is required than just the passage of time to justify a major modification of the parenting plan. And that's basically what you've been arguing to the court now and in the past. That is, this doesn't meet the requirements of the law. What you need to do is you need to exercise your visitation with the supervisor there that can see your interaction with the child and contemplating that that person will reach a point or issue an opinion that supervision is not required anymore. Further, with respect to your mental and emotional health that's been documented in the file, I don't know what it is today. I don't know what your situation is today because there is nothing before the court. And a declaration by someone that had that type of information which showed a change in circumstances is what the law would require for me to even begin to consider whether or not there's adequate cause for the court to make this change. So at this point, having said all that, the court at this point will find that there is no adequate cause to amend or revise the parenting plan. Based upon motion for contempt, the court will find that there is no obligation other than in the parenting plan for Mr. Duncan to facilitate or cooperate in this visitation. And he's solely responsible for having that visitation occur in terms of transportation. So Ms. Adams, you set the date for that visitation, and your daughter is not brought to you for visitation, then that is a violation of the parenting plan because he is responsible for transportation.
Can I ask a few questions when you're finished, please?
Yes, ma'am.
Okay, thank you. Thank you.
And with respect to the objection to relocation, you are absolutely correct. That is not a time with notice. There was no notice. The court is not pleased. However, the court, at the same time, because of this visitation schedule and the way the visitation is to be exercised, does not find the objection in any way your ability to exercise your visitation, nor does the court find that the distance between Wenatchee and Arlington and Wenatchee and Okanagan County is such that it is going to impact the visitation schedule. Finally, with respect to the objection to relocation, there is evidence based upon the pleadings on file that Mr. Duncan moved to Okanagan County because of the COVID pandemic, and at that point was not working path his work on the other side of the Cascade Mountains. So the court will find that the move was reasonable, but the court will find that it was not timely. The court will also tell you, Ms. Adams, that if you had an attorney and you filed this objection to the relocation, and it was necessary to have a hearing based upon the fact that it wasn't timely, this court would have awarded you attorney's fees for doing that. And I think Mr. Collier needs to let his client know that if this happens in the future, his client could be subject to sanctions of this court for failing to give notice. Now, one small thing, and I know it's not small to you, Adams, or probably to Mr. Duncan, but with respect to professional supervision, the court is not going to change that, but we need to find something to do that. When I say we, that doesn't mean the court's going to find it. So, Ms. Adams, you need to find that person, or Mr. Collier needs to find that person, and I'd like to hear first from Mr. Collier, and then I'll hear from you, Ms. Adams. Mr. Collier, what are we going to do about a professional supervisor if Dee Cummings at this point is unwilling to supervise?
Well, I think she is, number one. I think that Adams doesn't want to use her. Number two, I could come up with, I think, someone else in the valley. The name is escaping me. She's also works as a guardian ad litem that does supervise visits. Or then the third option would be, I'm sure there's multiple facilities over where my client's residing. I'm not familiar off the top of my head of their names, but I've seen them in other cases. But that would then require Adams to drive, so I'm not sure if she's willing to do that. So I can come up with a supervisor in Wenatchee, but I think it would probably be easier to do it over in the Arlington area, but that would require her to provide transportation for herself. So whatever she wants to do, frankly.
The court's not going to do that. The court's not going to order Ms. Adams to drive over to the other side of the mountains.
Okay, sure. I would then, Dee Cummings, I could ask her, I could send her an email, actually, specifically, or see Miss Adams, see if she's willing to do it. If not, then I would, I'll email the other person that I have in my computer somewhere who does supervise visits, and I think it's Rebecca something, but I guess the name escaped me, but I'll ask my assistant, and then I'll see what the availability is for that. And if
Mr. Collier,
yeah.
Mr. Collier, just a second.
Sure.
So with respect to your communication with Ms. Cummings,
yeah,
and any subsequent communication with a possible third party, you are to copy Ms. Adams in on those emails for communication.
No problem.
Because she needs to be in quote-unquote real time, seeing what your requests look like and seeing what the response of Ms. Cummings is to that request. All right?
Okay, that's not an issue. And if Ms. Cummings is unwilling to do it or doesn't have time, then I'll ask in the email if she could refer me to someone else in the valley that could be able to do it. I think that's probably our best bet.
Right. Now, Ms. Adams, you said you had questions, so I want to give you that opportunity.
Okay, thank you. I would like to address what we were just discussing because it seems the most pertinent. And I apologize if I sound like I'm uncooperative because I'm not trying to sound that way. My question was as to the supervisor, and whoever finds it, the other party thus far has been, not necessarily for that. More so me trying to find those options and them not being cooperative. I've stated that already today. But my three problems that I have with this pairing plan, in fact, that goes to my original question. If we walk away today with the very same parenting plan, it's not going to be workable. I'm not trying to be uncooperative, but it's just not going to be workable. Dee's name has to come off that parenting plan. I mean, I'm not saying that you have to, but I'm just saying it should be that way. I'm not even against Dee. I spoke to her for 13 minutes. I transcribed it. I just haven't notarized it, and so therefore I should probably copy him on that too. then he would be aware that she was unwilling for the last 3 months to set up supervision and unwilling to allow me out of the facility and unwilling to let me have the freedom of not having Mr. Duncan present 15 minutes before and 15 minutes after, just as though there was a restraining order in place. It could have been followed that way, but that didn't happen. And that's one of my major complaints with the things that I've already filed. And I appreciate you saying no travel, because I'm like, yeah, no, I have vehicles that are pretty much just sticking to in town if possible. My other question would be, could we do a layman? Could we do a layman supervisor? Does it have to be a charging professional?
That was the order of the court at that time.
At what time?
At the time that your parenting plan was issued.
I think that if that parent... So let me go back to my other page of notes, just so I don't get... D states that what the judge is asking for, Commissioner Safar, are preserved in the file, and that you have all the visitation notes. That was what she stated in the conversation that I've transcribed.
Well then, Ms. Adams, if that's the case, if you're relying upon the letter she sent to the court that was filed back in 2018, she said the supervised visits need to continue. No, actually, I'm not trying to argue with you, but that's not correct. If you look at that filing, at the very last paragraph, she recommends that I not see Maggie until she's seen behavioral health and then resume supervision. But my concern, that was the part that caused me to get an attorney, because that got, that gets a little, that was where the oversight was supposed to start happening outside of her. And it did not. That was what I was asking for, contempt. However, when I just talked to her, she basically said that she's trying to tell me that there's no parenting plan that states that she has to resume visits. And I have all of that. It's just not in front of the court today. I could just submit the video, but I transcribed it word for word so that I could file it that way. And I know I had a couple weeks to do so, but that was only if this came up as a question. Because then you guys have to see that further, her stance on this. Right. So, just a second, Ms. Adams.
Okay.
I understand what you're saying. My issue as the court is that you have not complied with the statute.
I can't provide my daughter to myself.
You have not complied with the statute that requires that there be an adequate cause showing based upon a substantial change in your circumstances and serving the best interests of the child to revise the parenting plan.
And that's my question too. I have a question concerning that comment, is what is documented as my mental health status that you're ruling on? What do you have in front of the courts that I don't see?
I don't have anything that's...
Everything that I've submitted...
Everything I've looked at was in the court file?
Yeah, everything that I've submitted has been my submission. Voluntary submission. And the most recent mental health evaluation is on the 10th page of that document. That both my attorney and Justin Collier I have proof of email. And I filed it with the court.
I just saw whatever was in the file.
Right, and on page 10, it states that my post-traumatic stress disorder is due to DV spousal abuse with my ex-husband, not my current husband. I know that doesn't matter, because as soon as I even start crying that, I get red flagged.
Ms. Adams, just a second. You had questions. Now we're kind of getting into arguing with me about my decision.
Well, I'm kind of trying to persuade you, not trying to argue with you. I apologize.
I understand. I understand you may not be pleased with my decision, but at this point, visitation will occur as ordered in the parenting plan, and at this point, if D. Cummings is willing to supervise, she was ordered to supervise. There's been no other professional supervisor at this point that has been agreed upon by the parties or proposed by the parties, so that's who the...
Not currently, no. But on January 29th of 2019, Hotchkiss made an order in the minutes that was not followed to date.
So at this point, the court's going to go ahead and it's going to prepare and enter orders on how to as none was found. Also, with respect to the professional supervisor and the parties, D. Cummings can't supervise, the parties can reach an agreement on a supervisor. That person will supervise. If you can't reach an agreement on a supervisor, one of you is going to have, well, you're going to have to come back to court again.
Okay, and that's why I've been coming back to court. And then what? So I put a couple of notes.
No, just 1 second.
Okay, but I've just got a couple of the notes I hadn't addressed. I'm sorry.
It's my turn.
And then it's mine.
No, it's not. You're done.
I thought you just stated on record that I could ask questions. I haven't even gotten to them yet.
But ma'am,
the parenting plan is the problem in this case, Your Honor.
You're pointing to the record.
The parenting plan is the problem in this case,
You
Your
are
Honor.
not asking questions. And so we're now done with that.
What can we do today to walk away with a workable parenting plan? Because it has not worked since it was entered.
The parenting plan is ordered to be followed as is.
Then why hasn't it been followed? That's a question.
Again, it appears that